Believe it or not, folks, there are now people talking about preventing old people from being able to exercise their right to keep and bear arms. People too old shouldn't be allowed to have firearms, so they say. That's according to a recent poll we're going to go over here from Newsweek. Stand by. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the U.S. Supreme Court Bar, and New York Times bestselling author. If you haven't subscribed to the Four Boxes Diner YouTube channel or followed us on Twitter, please do so. We appreciate the support. Okay, folks, believe it or not, I'm looking here at an article in the magazine Newsweek talking about a poll that they commissioned. And this poll basically asked, is there a maximum age? We often talk about minimum age before you can acquire a firearm. We talk about the litigations involving 18 to 20-year-olds, for example, going on across America right now. But this poll was different. They actually asked, is there a maximum age that you and I can get to that would allow the government to take away our right to keep and bear arms? That was what the poll asked. And it turns out that, according to Newsweek's reporting on this, a majority of Americans think that there should be a maximum age requirement for the purchase of firearms, though they can't agree upon the age, which is according to an exclusive poll run by the company of Redfield and Wilton Strategies on behalf of Newsweek. This was a poll of apparently 1,500 eligible U.S. voters conducted in the month of January after the shooting in Monterey Park, California, where it was an old guy, shot up, I think, one of the bars out there before getting disarmed at a second bar. Of course, those appear to be gun-free zones, but we won't get into that on this, because here we're going to talk about whether or not, under the Second Amendment, could a state or the federal government pass a law that says you're too old to exercise your right to keep and bear arms. Obviously, the answer is no. That's absurd for many reasons. Let's go over a few of them right here, right now. Number one, of course, is that under the United States Constitution, let's set aside the Second Amendment for a moment. Let's talk about the U.S. Constitution, the body of it itself, set aside the amendments. If you think about it, there is a requirement under the United States Constitution for how old a person has to be to become the President of the United States. I believe it's 35 years of age and you have to be born in the United States. Those are the requirements to become the President of the United States. Now, we have an 80-year-old Joe Biden in the White House. Now, you can debate a lot about Joe Biden, but the one thing we can agree on is he's, I think, 80 years old, and he's in the White House, and he's in control of the U.S. military and the so-called nuclear football, which means that we have an 80-year-old literally responsible for our nuclear arsenal and whether or not we, as Americans, should start a war across the world using nuclear weapons. So it seems to me that if Americans can trust a 80-year-old with the nuclear football, we certainly can trust older Americans with the right to keep and bear arms. Just an observation right off the top. But let's go beyond that and actually look at what the United States Supreme Court has said interpreting the Second Amendment's right to keep and bear arms. Obviously, there is no age restriction whatsoever on the Second Amendment. And if you compare that with the fact that when the Founding Fathers cared about age, such as the age at which you have to achieve before you can run for the House, before you can run for the Senate, before you can run for the White House, certainly to the extent age got considered, it wasn't considered in the context of the Bill of Rights. So I think that's quite telling in and of itself, because if the Founding Fathers thought age was important to the Bill of Rights, including the Second Amendment, they could have written it in there. Moreover, the Supreme Court has already defined who the people are, and this is something we probably should do a little bit more analysis of the text of the Second Amendment. If you go back to the Heller decision in 2008, it talks about the right of the people. And it goes on to say that the first salient feature of the operative clause is that it codifies a right of the people. The Supreme Court wrote, the unamended Constitution and the Bill of Rights use the phrase right of the people two other times in the First Amendment's Assembly and Petition Clause and in the Fourth Amendment Search and Seizure Clause, in addition to the Second Amendment. So the right of the people falls squarely within the Bill of Rights, which deals with individual rights, fundamental individual rights, in no fewer than 3 different instances. This is what the Supreme Court said in the Heller case. And this is what the court specifically said, quote, all three of these instances unambiguously refer to individual rights, not collective rights, or rights that may be exercised only through participation in some corporate body, period, close quote. So the Supreme Court in Heller already said that the Second Amendment is an individual right that belongs to the people. Now, who exactly are the people? Well, the Supreme Court answered that question as well. And remember, the text of the Second Amendment says the right of the people to keep and bear arms shall not be infringed. The way to interpret that is obviously it's some common sense involved, but also if you have any doubts, just go to look at the Supreme Court's precedents. They define all these terms. This is what the Supreme Court defined the people as in the context of the Second Amendment. In Heller, it says, quote, what is more, in all of the various provisions of the Constitution that mention the people, the term unambiguously refers to all members, hear what I just said, all members of the political community, not an unspecified subset. This is a very important fact, not only for the discussion of can you be too old to lose your Second Amendment rights? The answer is no, because you are obviously part of the people at your age, but it also goes to show you that all of the people are included in the context of the plain text of the Second Amendment and not just quote-unquote law-abiding people, which is what the anti-gunners are trying to get to and try to narrow the scope of who's entitled to keep and bear arms. But again, we'll talk about the concept of law-abiding in the context of the Second Amendment in a separate video. But let us continue on. The Heller Court also said that the people protected by the Fourth Amendment and the First and the Second Amendments, and to whom rights and powers are reserved for the Ninth and Tenth Amendment, refers to a class of persons who are part of a national community or who have otherwise developed sufficient connection with this country to be considered part of that community. So that's a Supreme Court case of Heller talking about, I think the case is Verdugo. That's right, United States versus Verdugo. You don't need to know that other than the Supreme Court says that basically all the people here in the United States are part of the people who get the benefit of the right to keep and bear arms. No distinction there between young and old, and certainly no suggestion that older people lose their right to keep and bear arms, nor should it. The only other point I want to make that comes up is some people have pointed out to me, hey, Mark, when you defend the right of 18 to 20-year-olds and their right to keep and bear arms, you often point out that in 1791, the Second Amendment and the rest of the Bill of Rights was adopted by the first Congress. But then you go on to say, in the following year, the year of our Lord 1792, the Congress passed the Militia Act of 1792, and in it says that members of the militia are those free white men between the ages of 18 and I think 45. And then you say, well, does that mean that people over 45 don't have the right to keep and bear arms? Because the list, and the answer is no, that's not what it means at all. The only purpose of using the Militia Act of 1791 is to show that 18 to 20-year-olds are allowed to have the right to keep and bear arms clearly at the time of the founding. The reason why this is the case is because what the Militia Act of 1792 said is that anyone between the ages of 18 and 45 had the obligation to bring their private arms and their private ammunition and the like. They didn't have to bring them all. They didn't have to bring all their guns and all their ammunition, by the way, just a specified subset of what they owned. But they had to bring a musket or a rifle, an ammunition of black powder, whatever it is, private arms. They had to bring their private arms that they owned privately, personally and privately, to militia muster for the purposes of satisfying that civic duty. But again, they brought to the muster their own private arms. And because 18 to 20-year-olds were part of that group that had to bring their private arms to militia muster, obviously the 18 to 20-year-olds at the time of the founding had to get the guns and the ammunition and the black powder from somewhere. Obviously, they had to buy it from somewhere. And again, that is why 18 to 20-year-olds clearly have the right to keep and bear arms, because the government that has the burden to show that 18 to 20-year-olds at the time of the founding were not entitled to the right to keep and bear arms cannot show any such thing. In fact, the only relevant law at the time of our founding suggests us the opposite, that 18 to 20-year-olds at the time of the founding had an obligation to bring their private arms. And again, implicitly, how else were they going to get these private arms and ammunition without buying them? They had to be able to buy them. So it just goes to show the historical record is all one way when it comes to 18 to 20-year-olds. So now we segue into what does the Militia Act of 1792 mean for people that were over 45 and not part of the militia? It has absolutely no bearing whatsoever on the question, because again, as the Supreme Court said, the term the people, as in the right of the people to keep and bear arms, consists of all Americans, according to the Supreme Court, in Heller, and that would include people over the age of 45. And again, keep in mind that when the Founding Fathers wanted to write in an age restriction preventing certain people from being able to do things under the U.S. Constitution, like if you're 20 years old and you wanted to run to be the president, you weren't allowed to do that. The Founding Fathers wrote into the document that it was too young, the same with the U.S. Senate, and so on and so on. So again, when the Founding Fathers in the 18th century wanted to limit your rights or your ability to do something in our new country, when it came to the federal government and our Bill of Rights and so on, when they wanted to limit your rights based on an age requirement, they knew exactly how to write that into the Constitution. So when we looked at the Second Amendment, do we see any kind of age restrictions applied to the Second Amendment saying that at some point you're too old? The answer obviously is no, but that's not because the Founding Fathers were not aware of age issues. They certainly were aware of age issues, which is why they wrote it in to the other articles of the Constitution dealing with how old you need to be to become the president, to run for the House of Representatives, or to be a member of the United States Senate. Okay, I hope this helps assuage some of your concerns, perhaps from this survey that Americans supposedly want to limit old people from having firearms based on this Newsweek article, which I'll link to down below. Hopefully this assuages some of your concerns that we should be in good shape and I'm giving you some of the intellectual ammunition you need to fight back. And if you haven't subscribed to the Four Boxes Diner, please do so. We'd appreciate it. And we'll see you again soon here at the Four Boxes Diner.
Orders up. Table 2A.